Justice Sotomayor, with whom Justice Kagan and Justice Jackson join. Dissenting. In Donald J. Trump v. United States. Decided July 1st, 2024. Today's decision to grant former presidents criminal immunity reshapes the institution of the presidency. It makes a mockery of the principle, foundational to our Constitution and system of government, that no man is above the law. Relying on little more than its own misguided wisdom about the need for bold and unhesitating action by the president, the court gives former President Trump all the immunity he asked for, and more. Because our Constitution does not shield a former president from answering for criminal and treasonous acts, I dissent. Part 1. The indictment paints a stark portrait of a president desperate to stay in power. In the weeks leading up to January 6, 2021, then-President Trump allegedly spread that there had been outcome-determinative fraud in the election and that he had actually won, despite being notified repeatedly by his closest advisors that his claims were untrue. When dozens of courts swiftly rejected these claims, Trump allegedly pushed officials in certain states to ignore the popular vote, disenfranchise millions of voters, dismiss legitimate electors, and ultimately cause the ascertainment of and voting by illegitimate electors in his favor. It is alleged that he went so far as to threaten one state election official with criminal prosecution if the official did not find 11,780 votes Trump needed to change the election result in that state. When state officials repeatedly declined to act outside their legal authority and alter their state election processes, Trump and his co-conspirators purportedly developed a plan to disrupt and displace the legitimate election certification process by organizing fraudulent slates of electors. As the date of the certification proceeding neared, Trump allegedly also sought to use the power and authority of the Justice Department to bolster his knowingly false claims of election fraud by initiating sham election crime investigations and sending official letters falsely claiming that the Justice Department had identified significant concerns that may have impacted the election outcome while falsely presenting the fraudulent electors as a valid alternative to the legitimate electors. When the department refused to do as he asked, Trump turned to the vice president. Initially, he sought to persuade the vice president to use his ceremonial role at the January 6th certification proceeding to fraudulently alter the election results. When persuasion failed, he purportedly attempted to use a crowd of supporters that he had gathered in Washington, D.C., to pressure the vice president to fraudulently alter the election results. Speaking to that crowd on January 6th, Trump falsely claimed that based on fraud, the vice president could alter the outcome of the election results. When this crowd then violently attacked the Capitol and halted the proceeding, Trump allegedly delayed in taking any step to rein in the chaos he had unleashed. Instead, in a last desperate ploy to hold on to power, he allegedly attempted to exploit the violence and chaos at the Capitol by pressuring lawmakers to delay the certification of the election and ultimately declare him the winner. That is the backdrop against which this case comes to court. Part 2. The court now confronts a question it has never had to answer in the nation's history: whether a former president enjoys immunity from federal criminal prosecution. The majority thinks he should, and so it invents an atextual, ahistorical, and unjustifiable immunity that puts the president above the law. The majority makes three moves that, in effect, completely insulate presidents from criminal liability. First, the majority creates absolute immunity for the president's exercise of core constitutional powers. This holding is unnecessary on the facts of the indictment, and the majority's attempt to apply it to the facts expands the concept of core powers beyond any recognizable bounds. In any event, it is quickly eclipsed by the second move, which is to create expansive immunity for all official acts. Whether described as presumptive or absolute under the majority's rule, a president's use of any official power for any purpose, even the most corrupt, is immune from prosecution. That is just as bad as it sounds, and it is baseless. Finally, the majority declares that evidence concerning acts for which the president is immune can play no role in any criminal prosecution against him. That holding, which will prevent the government from using a president's official acts to prove knowledge or intent in prosecuting private offenses, is nonsensical. Argument by argument, the majority invents immunity through brute force. Under scrutiny, its arguments crumble. To start, the majority's broad official acts immunity is inconsistent with text history and established understandings of the president's role. Moreover, it is deeply wrong, even on its own functionalist terms. Next, the majority's core immunity is both unnecessary and misguided. Furthermore, the majority's illogical evidentiary holding is unprecedented. Finally, this majority's project will have disastrous consequences for the presidency and for our democracy. Part 3. The main takeaway of today's decision is that all of a president's official acts, defined without regard to motive or intent, are entitled to immunity that is at least presumptive and, quite possibly, absolute. Whenever the president wields the enormous power of his office, the majority says, the criminal law cannot touch him. This official act's immunity has no firm grounding in constitutional text history or precedent. Indeed, those standard grounds for constitutional decision-making all point in the opposite direction. No matter how you look at it, the majority's official act's immunity is utterly indefensible. Section A. The majority calls for a careful assessment of the scope of presidential power under the Constitution. For the majority, that careful assessment does not involve the Constitution's text. I would start there. The Constitution's text contains no provision for immunity from criminal prosecution for former presidents. Of course, the silence of the Constitution on this score is not dispositive. Insofar as the majority rails against the notion that a specific textual basis is required, it is attacking an argument that has not been made here. The omission in the text of the Constitution is worth noting, however, for at least 3 reasons. First, the framers clearly knew how to provide for immunity from prosecution. They did provide a narrow immunity for legislators in the speech or debate clause. They did not extend the same or similar immunity to presidents. Second, some state constitutions at the time of the framing specifically provided express criminal immunities to sitting governors. The framers chose not to include similar language in the Constitution to immunize the president. If the framers had wanted to create some constitutional privilege to shield the president from criminal indictment, they could have done so. They did not. Third, insofar as the Constitution does speak to this question, it actually contemplates some form of criminal liability for former presidents. The majority correctly rejects Trump's argument that a former president cannot be prosecuted unless he has been impeached by the House and convicted by the Senate for the same conduct. The majority ignores, however, that the impeachment judgment clause cuts against its own position. That clause presumes the availability of criminal process as a backstop by establishing that an official impeached and convicted by the Senate shall nevertheless be liable and subject to indictment, trial, judgment, and punishment according to law. That clause clearly contemplates that a former president may be subject to criminal prosecution for the same conduct that resulted or could have resulted in an impeachment judgment, including conduct such as bribery, which implicates official acts almost by definition. Section B. Aware of its lack of textual support, the majority points out that this court has recognized presidential immunities and privileges rooted in the constitutional tradition of the separation of powers and supported by our history. That is true as far as it goes. Nothing in our history, however, supports the majority's entirely novel immunity from criminal prosecution for official acts. The historical evidence that exists on presidential immunity from criminal prosecution cuts decisively against it. For instance, Alexander Hamilton wrote that former presidents would be liable to prosecution and punishment in the ordinary course of law. For Hamilton, that was an important distinction between the King of Great Britain, who was sacred and inviolable, and the President of the United States, who would be amenable to personal punishment and disgrace. In contrast to the king, the president should be subject to personal responsibility for his actions, standing upon no better ground than a governor of New York, and upon worse ground than the governors of Maryland and Delaware, whose state constitutions gave them some immunity. At the Constitutional Convention, James Madison, who was aware that some state constitutions provided governors immunity, proposed that the convention consider what privileges ought to be allowed to the executive. There is no record of any such discussion. Delegate Charles Pinckney later explained that the convention which formed the Constitution well knew that no subject had been more abused than privilege, and so it determined to limit privilege to what was necessary, and no more. No privilege was intended for the executive. Other commentators around the time of the founding observed that federal officials had no immunity from prosecution, drawing no exception for the president. James Wilson recognized that federal officers who use their official powers to commit crimes may be tried by their country, and if their criminality is established, the law will punish. A grand jury may present, a petty jury may convict, and the judges will pronounce the punishment. A few decades later, Justice Story evinced the same understanding. He explained that when a federal official commits a crime in office, it is indispensable that provision should be made that the common tribunals of justice should be at liberty to entertain jurisdiction of the offense for the purpose of inflicting the common punishment applicable to unofficial offenders. Without a criminal trial, he explained, the grossest official offenders might escape without any substantial punishment, even for crimes which would subject their fellow citizens to capital punishment. This historical evidence reinforces that, from the very beginning, the presumption in this nation has always been that no man is free to flout the criminal law. The majority fails to recognize or grapple with the lack of historical evidence for its new immunity. With nothing on its side of the ledger, the most the majority can do is claim that the historical evidence is awash. It claims that the court previously has described the relevant historical evidence on the question of presidential immunity as fragmentary and not worthy of consideration. Yet the court has described only the evidence regarding the president's immunity from damages liability as fragmentary. Moreover, far from dismissing that evidence as irrelevant, the Fitzgerald Court was careful to note that the best historical evidence clearly supported the immunity from damages liability that it recognized, and it relied in part on that historical evidence to overcome the lack of any textual basis for its immunity. The majority ignores this reliance. It seems history matters to this court only when it is convenient. Section C. Our country's history also points to an established understanding, shared by both presidents and the Justice Department, that former presidents are answerable to the criminal law for their official acts. Consider Watergate, for example. After the Watergate tapes revealed President Nixon's misuse of official power to obstruct the Federal Bureau of Investigation's investigation of the Watergate burglary, President Ford pardoned Nixon. Both Ford's pardon and Nixon's acceptance of the pardon necessarily rested on the understanding that the former president faced potential criminal liability. Subsequent special counsel and independent counsel investigations have also operated on the assumption that the government can criminally prosecute former presidents for their official acts where they violate the criminal law. Indeed, Trump's own lawyers during his second impeachment trial assured senators that declining to impeach Trump for his conduct related to January 6th would not leave him in any way above the law. They insisted that a former president is like any other citizen and can be tried in a court of law. Now that Trump is facing criminal charges for those acts, though, the tune has changed. Being treated like any other citizen no longer seems so appealing. In sum, the majority today endorses an expansive vision of presidential immunity that was never recognized by the founders, any sitting president, the executive branch, or even President Trump's lawyers, until now. Settled understandings of the Constitution are of little use to the majority in this case, and so it ignores them. Part 4. Section A. Setting aside this evidence, the majority announces that former presidents are absolutely, or at least presumptively, immune from criminal prosecution for all of their official acts. The majority purports to keep us in suspense as to whether this immunity is absolute or presumptive, but it quickly gives up the game. It explains that, at a minimum, the president must be immune from prosecution for an official act unless the government can show that applying a criminal prohibition to that act would pose no dangers of intrusion on the authority and functions of the executive branch. No dangers, none at all. It is hard to imagine a criminal prosecution for a president's official acts that would pose no dangers of intrusion on presidential authority in the majority's eyes. Nor should that be the standard. Surely some intrusions on the executive may be justified by an overriding need to promote objectives within the constitutional authority of Congress. other intrusions may be justified by the primary constitutional duty of the judicial branch to do justice in criminal prosecutions. According to the majority, however, any incursion on executive power is too much. When presumptive immunity is this conclusive, the majority's indecision as to whether official acts immunity must be absolute or whether instead presumptive immunity is sufficient hardly matters. Maybe some future opinion of this court will decide that presumptive immunity is sufficient and replace the majority's ironclad presumption with one that makes the difference between presumptive and absolute immunity meaningful. Today's court, however, has replaced a presumption of equality before the law with a presumption that the president is above the law for all of his official acts. Quick on the heels of announcing this astonishingly broad official acts immunity, the majority assures us that a former president can still be prosecuted for unofficial acts. Of course he can. No one has questioned the ability to prosecute a former president for unofficial, otherwise known as private, acts. Even Trump did not claim immunity for such acts, and as the majority acknowledges, such an immunity would be impossible to square with Clinton v. Jones, 1997. This unremarkable proposition is no real limit on today's decision. It does not hide the majority's embrace of the most far-reaching view of presidential immunity on offer. In fact, the majority's dividing line between official and unofficial conduct narrows the conduct considered unofficial almost to a nullity. It says that whenever the president acts in a way that is not manifestly or palpably beyond his authority, he is taking official action. It then goes a step further. In dividing official from unofficial conduct, courts may not inquire into the president's motives. It is one thing to say that motive is irrelevant to questions regarding the scope of civil liability, but is quite another to make it irrelevant to questions regarding criminal liability. Under that rule, any use of official power for any purpose, even the most corrupt purpose indicated by objective evidence of the most corrupt motives and intent, remains official and immune. Under the majority's test, if it can be called a test, the category of presidential action that can be deemed unofficial is destined to be vanishingly small. Ultimately, the majority pays lip service to the idea that the president, charged with enforcing federal criminal laws, is not above them, but it then proceeds to place former presidents beyond the reach of the federal criminal laws for any abuse of official power. We've come to the end of part 1 of this opinion, but don't worry, next episode we will pick up right where this episode left off. Until then, thanks for listening to What SCOTUS Wrote Us.